Hello, my Ibmore brothers. This is a video of the timeline of how affirmative action benefits white women. In 1954, the U.S. Supreme Court in Brown v. Board of Education ruled that separate but equal doctrine violates the Constitution. So this pretty much so broke down the segregated policy on education. You already had Eisenhower breaking down the segregated policy in the military previously. In 1961, John F. Kennedy, president, created the Council of Equal Opportunity and an executive order. The executive order I will link below, and that ensures federal contractors hire people regardless of race, creed, or color, or national origin. So the origins of what we call affirmative action is not law. It's actually a executive order, just like Trump passed executive orders for Patriots Day and to put a ban on Arabs from being able to come into the country from specific countries, etc., etc. And the pipeline that is being drilled out, being fought right now by Native Americans in the Dakotas. 1964, the Civil Rights Act rendered discrimination illegal in the workplace. And that was the 64 Civil Rights Act, which was kind of the origins of the equal opportunity employment. That's all it meant. It just meant anyone that was receiving any type of federal employment, anyone receiving any type of federal grants, federal funding, it was illegal for you to discriminate in the workplace against a person. And quite a few of women are working in federal employment anyway. A large segment of them are. 1978, you had the University of California versus Bakke, and it was a reverse discrimination. This was for the med school, and they said it was illegal. Well, that's what they alleged, to use racial quotas because it violated the 14th Amendment Equal Protection Clause. You'll hear the Equal Protection Clause oftentimes. You're supposed to treat people equally and unilaterally in government positions, etc. So you can't have any type of advantage or equity over one other person. Many of the things that you see currently with the child support laws and paternity fraud is actually a violation of Equal Protection Clause in the 14th Amendment. So most men actually have a opportunity to fight against the unjust policies and laws that unfairly target and create an advantage over one group over another based on gender, ethnicity, etc. And it was supposed to be used, not supposed to be used for a factor of admission. This was an individual who was trying to get into a med school, and as I stated in the previous video, most med schools, they knew that ethnic European white men or white women weren't usually going to work in inner cities. They weren't. So they want to get enough representation of different cultures and people that usually will work in a specific area that they're from. 1995, University of Michigan. Here's where we get into University of Michigan. Rejects a college application from Jennifer Gratz. She was pretty much from the suburbs, just like where I live at. And she's white. So she took it to court in 1997. Gratz versus Bollinger, which was filed in federal court in the Eastern District of Michigan. The University of Michigan is sued by white students. So it wasn't just one, it was multiple white women, including Jennifer Gratz and many others, to claim the undergraduate and law school affirmative action policies using race or gender was a factor in admissions. And it was a violation of the Equal Protection Clause of the 14th Amendment, or Title 6 of the Civil Rights Act of 1964, which I'll link below. And December 3rd, 1997, a similar case in Gruder versus Bollinger. Now this was a different person, It was a different white woman, was filed in federal court in the Eastern District of Michigan yet again. She was denied admission to the University of Michigan Law School. So basically, she piled on to the Gratz versus Bollinger case. This was Grutter, Barbara Grutter. And she felt that black people had lower test scores and grades and were given an unfair advantage due to race. Now, I explained this earlier. You had quite a few people that have family members that have graduated, and they're going to get points from that university, from better universities. You have students that have gone to that university in undergrad that applied for it. There's a whole type of point systems that it is what it is. So this went all the way into December 2000, and Gratz versus Bollinger, the first girl, her case was ruled that did not violate the standards set by the Supreme Court. So Grutter, her case was filed in March 2001, and the case ruled the University of Michigan's law school admission policy is unconstitutional. So she was able to overturn Gratz versus Bollinger, this Barbara Grutter. So in December 2001, the Sixth Circuit Court of Appeals heard both appeals in both University Michigan cases. It took until May 2002. The Sixth Circuit Court of Appeals reversed the district's court decision in Grutter versus Bollinger. Then, in January 17, 2003, the mission of George Bush administration filed a Friends of the Court, I believe that's an amicus curiae brief with the Supreme Court opposing the University of Michigan's affirmative action program. In April 1st, 2003, the Supreme Court hears oral arguments on both cases. The U.S. Solicitor General Theodore Olson offers arguments in support of the plaintiffs. This is where I was telling you that you had feminism, you had all these policies. They had to have a person in the government, high positions, to bring most of these laws and policies in, period. So whether you're Democrat or Republican, you have individuals that worked in government that helped bring policies that were detrimental for men intentionally. I digress. In June 2003, Supreme Court rules Grutter v. Bollinger and University of Michigan law may give preferential treatment to minorities during the admission process. The law policy is upheld with a vote of 5-4. Now, there were some people that dissented and they left their opinion on the Supreme Court. I might link that below. Dissent just means that they didn't agree with it. In 2003, in Gratz v. Bollinger, the undergraduate policy in which point systems give specific weight to minority over applicants is overturned, 6-3. So these two white women and their cases were used as a catalyst to get change. So this was the ending of point systems in undergrad. So they say, okay, well, that sets precedents. So usually what happens is when a case is overturned and you remove something, oh, that sets precedents. So they will usually go back to the court, go right back up the chain from state, federal, and eventually regional, and then all the way to the Supreme Court again. And we see this in 2006. Michigan electorate strikes down affirmative action by approving a proposition barring affirmative action in public education, employment, and contracting. Then it went all the way into 2007. After the Supreme Court sends the case back to district court, the case is dismissed. Gratz and her federal plaintiffs settle for $10,000 in administrative costs, but do not receive damages. Then we get to Abigail Noel Fisher. She's a very poor academic student. from Texas, trying to apply for the University of Texas. She argued that the university should not use race as a factor in admission policies that favor African American, notice this, and Hispanic applicants over white and Asian Americans. Now, we all know that Asian Americans that are applying to university, they're going to send their top students. So she was just trying to combine them intentionally because she was trying to show that some type of allying force. But we all know that China is only going to send its top students, same as Korea, same as India, and they always do well on test scores, undergrad wise, to get in. That's just the way it is. Not always, but a high percentage of them usually do well score wise on the standardized test to get admission into these universities. They take the best of the best, period. So in July 2011, an appeals court overturns Michigan's 2006 ban on the use of race and or gender as a factor in admission or hiring practices. This is essential because this sets a dangerous precedence. So November 2012, the Sixth Circuit Court of Appeals throws out Michigan's 2006 ban on affirmative action in college admissions and public hiring, declaring it unconstitutional. In 2013, the Supreme Court does not rule on the school's admission policy for the University of Texas. Instead, it sends it back to the lower courts for further review. And then in 2013, October, we heard the Supreme Court decision in Michigan for admission based on race and gender. And then in a 6-2 vote, the court ruled the lower court did not have the authority to set aside the law. So they upheld Michigan's voter-approved law that bans use of racial criteria in college admission. Now, what are the results of this? Well, the results are quite simple. Michigan now has the lowest percentage of minorities in law school. Period. Now, this is quite interesting. You say, well, they have the lowest percentage of minorities in law school. How does that, well, I don't know. How does that affect? Well, guess who's mentioned as a minority? In 1968, the Civil Rights Act included one specific modification from 64 and from 65 Civil Rights Act, which are executive orders, by the way. Gender. So now, University of Michigan, which had a large percentage of ethnic minority European women, has a very low percentage. It's so low that they are trying to increase the percentage of ethnic European women in their law school. And it doesn't look like it's going to change. So by removing affirmative action into law school admissions with Gratz and Bollinger, Bakke versus University of California Med School, and several other law cases, which I'm not going to mention, that were filed for so-called reverse discrimination under the auspices of the Civil Rights Act and Title IX. White women now have the lowest percentage of admission in Michigan law school history. Now, other people are benefiting from this. Asians, there's some engineering students that are now going into law. And most of your top African American applicants, so-called ebony American applicants, who have good grades, they can get into any school. You only need a median LSAT score on the top 5 percentile. And if you can get that, Harvard's going to call you, Yale's going to call you, Columbia's going to call you, Dartmouth. You're going to get to Cambridge. You're going to get to Oxford. You're going to get to the top schools, Duke, Stanford. You don't really have to pick Michigan. So they're not getting any of the top minorities to go to their school, and they can't fulfill the median amount of ethnic European women in their school also. So they have to go outside the country and get people that are engineers and chemists and physicists, and they give them opportunities to go to law school while they're getting visa certification for other majors. And these are highly intelligent guys from some of the you know top countries where education is truly valued: Korea, India, parts of Pacific Asia, parts of Western Asia. So by trying to hurt the admission opportunities of ebony Americans, they only really hurt themselves. That's very interesting. All right, my SYSBM, my IBMOR, my WOS, my EBM, and all my brothers out there, keep your head up. That's it for today.